Seth, who's first?
It is Tektara.
Okay, you could bring him in.
All
I
right.
think I started the recording, did I?
Yeah, it's streaming and the Zoom is recording, yes.
Okay, great. Thank you. Bye, Sasha. Parties on Tektara. Mr. Fortner, Mr. Tillman, are you there?
Yes, Your Honor.
Here,
Good
Your Honor.
morning.
Good morning.
Good morning, Your Honor.
Mr. Tillman, I haven't seen you in that garden in a long time.
Oh, I had to get out here today because, as you know, summer will be drawing to a close.
I'm going to turn this camera on too. I don't know if you all can see. Hold on. Lean in a little bit. Judge Cusick is sitting with me today. He is rotating over from the criminal division to civil. So he's sitting with me on this motion call.
All right,
Okay.
Judge Cusick. I hadn't met him, but I heard Judge Snow told me this week. Which docket is he going to get?
He's taking Judge Hughes's docket.
Oh, okay.
He's a great man. He went to the
If you
University of
say
Notre
so.
Dame.
Well, look, Your Honor, if you speak highly on him, then we know it comes from a good source. No question about it.
He said thank you. All right, Madam Clerk, whenever you're ready, please call this case.
Calling case number 21012-685, Tektara Court versus Smith.
Good morning, Your Honor.
Go ahead, David. I'm sorry.
Good morning, Your Honor. David
I'm sorry.
Tillman appearing on behalf of Plaintiff Tektara Corporation.
Your Honor, Mike Ford is here on behalf of plaintiff. I'm sorry, defendant.
Your Honor, as the court is well aware, this is plaintiff's motion for leave to file second amended complaint. The facts and history of this case are well known to the court. In September of 2021, Tektara's complaint against Ms. Smith was made in 2 counts, namely breach of contract and specific performance.
Hey,
In
Your Honor, I don't have
August,
an objection. I'm not objecting to Dave's request if that's what if the court wanted to grant it.
given that the motion is unopposed, Your Honor, plaintiff would respectfully request that the court grant leave for it to file a second amended complaint in a form substantially similar to that attached to the motion as Exhibit E.
Okay, well, under the circumstances, since Mr. Fortner is not objecting, your motion will be granted. How much time do you need? Can you do it in 7 days?
Yes, Your Honor.
All right.
7 days from today or 7 days from when the order is entered?
7 days from entry of the order.
Thank you, Your Honor.
All right, you guys have a good weekend.
You too. Thank
Thank you,
you.
Your Honor. Dave, send me a proposed order, okay?
I will. Thank
Thanks.
you.
That's who's next.
Ali versus, hold up. Auto owners. Bringing them in.
Okay, bring them in, please. Yeah. Parties on Ali?
Yes, good morning.
Good morning, Your
Good
Honor.
morning. Madam Clerk, please call this case.
Calling case number 25006-906, Ali et al. Versus Auto Owners Insurance Company.
Your appearances for the record, please.
Good morning, Your Honor. Elizabeth King appearing on behalf of the plaintiffs, Ali.
Good morning, Your Honor. Elizabeth Jorameri appearing on behalf of defendant auto owners.
Good morning. You know, I'm concerned about this motion that was filed by defendant auto owners. Did you write this motion?
I believe one of my associates did, Your Honor.
Well, I think you need to talk to your associates about using cut and paste pleadings and filing them with the court. Have you read the motion that was submitted?
Are you talking about the motion to compel the authorizations, Your Honor?
Yes, I am.
Yes, because there was two motions. That's why I wanted to clarify with the court. Yes, I believe I've read it to prepare for today.
And do you have any concerns with what was submitted to this court?
I didn't see anything specifically. If the court,
Oh, okay, great. Well, let me pull it up on the share screen. Give me a moment.
of course.
You do agree that this is a case that deals with a property loss and a contractual dispute between your insured and your client, correct?
Yes, Your Honor. It's a water loss claim.
So why would there I have a motion citing law regarding PIP benefits.
I did see that, Your Honor.
Oh, okay.
Yeah. I did see that. I think that they were trying to, indicate a correlation between establishing residency and PIP cases in this case. I mean, the issue with this case, Your Honor, is that there's a question of the plaintiff's primary residence on the date of loss, and that was one of the basis for the denial of the claim. And so we wanted the tax returns to help establish where they are declaring under penalty of perjury on their tax returns what their primary address is. I have no issue with the plaintiff if they want to produce the records and redacting all of the financial information. I don't need to see the Ali's financial information, but I do want to see where they are representing to the IRS and to the state of Michigan what their primary address is. And so that is the basis for the request for the authorizations for those records. But as I've said, I'm willing to not subpoena them myself if the plaintiff can produce them and redact accordingly. I just want to see where they are representing that their primary address is.
Well, hold on. Give me just a second.
Okay.
I'm going to put on the share screen the
Okay.
motion that you filed
Yes, Your Honor.
or that one of your associates filed. You should be able to see that now.
I do now.
Paragraph 6
I do.
says, Paragraph 6 says, additionally, pursuant to Michigan Court Rule 2.302A3, a party claiming damages for injury arising from a mental or physical condition must provide the other parties with executed medical record authorizations in the form approved by the state court administrator's office. You do see that?
I see that, Your Honor.
And then line 10, therefore, defendant seeks an order compelling the executed authorizations.
I agree that the language under paragraph 7, or excuse me, paragraph 6 is not applicable here, and I apologize to the court. That obviously deals with a matter involving a mental or physical condition. It does not have anything to do with a contract matter.
Nothing.
Yeah, I agree with the court. I apologize to the court for that. That should not have been included.
Is there anything else you want to say?
No, Your Honor. I mean, like I said, we just want to see where we've been trying to gather a number of documents, and the plaintiff has provided some to establish the plaintiff's primary residence at the time of the alleged water loss. Taxes typically link a person to a permanent home by way of filing history, and it creates a sworn government record of where the plaintiffs claim they live. We would like to see where they represented to the state of Michigan and to the IRS that their primary residence was, particularly in regard to at the time of this alleged loss. We are willing to consider having all the financial information redacted, but we would, I guess, like to see the documents that show the address.
Okay, thank you.
Thank you, Your Honor.
On behalf of the plaintiff, you may.
Thank you, Your Honor. I would just rely on my brief at this point. It's clear that the court has read the written documents, and so I will leave it to the court's discretion. Thank you.
Okay. Well, I'm going to order that. I think an authorization is probably too broad. I don't think that they should be required to give you an authorization, but I do think that they should be required to produce the tax returns for the year of the loss, the year after the loss, and the year before the loss.
Okay.
And the financial information can be redacted.
Okay.
And also, if they claimed a homestead tax exemption, I think you should be entitled to that information.
Okay, Your Honor.
That homestead tax exemption is through the state, is it not?
I believe it is. That
All
would be
right.
on the state
So
return.
you're going to have 21 days to produce those documents on behalf of the plaintiff. 21 days from entry of the order.
Okay.
Submit the order, I'll sign it. You all have a good day. And tell your associates, don't be filing no cut and paste motions.
There will be a serious conversation today, Your Honor.
Okay, thank you. Have a good day.
Your Honor, I
Thank
did
you.
have one other motion. Do you have it on your docket? It's a motion to show cause Chubb Insurance for failing to
Oh, you know what? There's another motion. You have two motions today on this case. There's a motion to compel non-party compliance.
Yes, that's the one.
Let's move forward with that one.
Okay, Your Honor. This is defendant's motion to compel Chubb Insurance for failing to comply with a record subpoena. We had submitted a subpoena properly to Chubb Insurance. They have failed to comply. We filed this motion. They were properly served with the motion at the registered agent address. They had signed for it, and we still have not received the records from Chubb. So we are requesting that the court enter an order compelling Chubb's compliance with the record subpoena within 14 days.
Ms. King?
That's fine, Your Honor.
All right, Madam Clerk, the show cause hearing date will be what? All right, so the records will need to be produced. Officer Carvin, can you pull the calendar up to the future? The records will need to be produced no later than Friday, September 11th. If they fail to produce the records by September 11th, they'll have to appear before the court on the 25th to show cause for why they should not be held in contempt of court.
Very well, Your Honor. I'll prepare an order to that effect.
Okay. Also, ladies, I want to introduce you to Judge Cusick, who's sitting to my right. He is coming over to the civil division, taking over Judge Hughes's docket.
Oh, great. Wonderful.
Been on the bench for 10 years. He's been in the criminal division, but he'll be a welcome addition to us here in civil.
Nice to meet you.
Welcome, Your Honor. We look forward to working with you.
Yes.
He said thank you. Y'all can't hear. All right. Have a good weekend, ladies.
You too. Thank you. Bye-bye.
What'd you say, sir?
Is it supposed to be in person? September 25th?
No.
Oh, okay, sorry. Number 3 is Hoskins v. Clark, withdrawal.
Okay, hold on just a sec.
Oh, hold up.
You could bring in whoever's next, sir. Good morning.
Good morning.
Is this everyone we need for this case?
Yes, I believe so.
Yes,
Madam
Your
Clerk,
Honor.
whenever you're ready, please call this case.
Calling case number 25009-600, Hoskins versus Clark.
Your appearances for the record, please.
Yes, good morning. Brittany Thompson appearing on behalf of plaintiff Vanessa Leanne Hoskins.
Good morning.
Good morning.
Good morning. Jonathan Solish appearing on behalf of the defendant, Nathan Clark.
Good morning. We are here today on a motion to withdraw as counsel filed on behalf of plaintiff's counsel. Whenever you're ready, you may.
Correct. Yes, thank you. This is our motion to withdraw as counsel for the plaintiff Vanessa Leanne Hoskins. On March 23rd, 2026, we executed a fee agreement with the plaintiff. On June 25th, 2026, we were notified that the client wished to terminate that agreement, that there's been a breakdown in the attorney-client relationship, and that the client requests to proceed with her own representation. And so therefore, we would request that the court approve our petition to withdraw and permit the plaintiff in this case to represent herself.
What do you mean that she told you she wanted to represent herself?
She told me that she wanted to proceed with this matter with herself without representation. It is a partition matter, and I know that the parties are in communications about selling the property and splitting the expenses, so it is very much so likely that there's a resolution. But I haven't had
Would you
time
give
to-
her notice of today's proceedings?
Yes, I did.
What type of notice did you give her?
I served her with both mail notice and electronic notice, and she did execute a stipulation to withdraw as well, but we realized that that was not the appropriate format, so we also filed a motion.
When's the last time you spoke to her?
Let me check my email. It would have been when we confirmed notice of this petition, but my last email to her.
No, I didn't say email. I said, when is the last time you spoke to her?
Spoke to her? Okay, let me check my call log to give you the exact date. The last phone call that I would have had with the client would have been April 22nd.
So you haven't spoken to your client since April 22nd.
No, that's not. I have been in communications via email. I just have not spoken telephonically with my client since April 22nd.
Okay. So when you got an email from someone, your primary method of communicating with the client is in writing, not over the phone.
Correct.
Okay. And that last email exchange between you and her was what date?
July 24th.
I'm asking you these questions for a reason, because what I typically do is if I allow counsel to withdraw, I set the matter for a status conference, at which time the party will have to appear and either indicate that they intend to represent themselves, or new counsel will have had to enter an appearance on their behalf. And if they fail to appear at that time, I will entertain a motion to dismiss. And so I'm asking you these questions so that the record can be made regarding your communications with your client, so that in the event the case gets dismissed, there's a record of your communications should your former client accuse you of being derelict in your duties. So that's why I'm asking that.
Understood. Thank you very much. And as a matter of note, should it be at all helpful to the court, there is a adjourned status conference for this matter set for September 1st. So I don't know if that date would be helpful to combine those matters. It's my understanding that the client also intends to be present on September 1st anyway.
I'm just looking at the calendar. Give me a second. Okay. Kim, is that September 1st Zoom status conference a good date to have the status conference? Okay, so here's what I'm going to do. Well, first of all, let me hear from defendants counsel.
Good morning. We have no
Good morning.
objection. We have no objection to plaintiff's motion.
Is it true that you continue to be in negotiations to resolve this matter?
Not that I'm aware of. I don't know whether my client has spoken with. I don't know whether my client has spoken with Attorney Thompson's client. I believe the last thing that I'm aware of happening in this case is we entered an order to set a price floor on the house. As a partition matter, they are selling the property. There's been a real estate agent retained to do that, and there's been a price floor set, and the house is up for sale. That's my current understanding of where things are. I'm not sure whether the parties have talked amongst themselves outside of that.
So these people know each other.
Yes, it's my understanding that they were previously in a romantic relationship when they purchased the property, and they are no longer in that relationship, but they do have communications.
Okay. All right, so what I'm going to do is I'm going to grant your motion to withdraw. And in your order allowing you to withdraw, you need to include your clients, which I see that you already did in your motion, but it has to go in the order. You have to include their last known address, telephone number, and email address. It should indicate that the status conference is going to be held via Zoom, that failure to appear may result in the case being dismissed, and it should include detailed login. Whose device is that? That's your radio? Okay. So you should include that contact information in the order, as well as Zoom login instructions to ensure that your former client will be able to access the proceedings.
Not a problem. I will get that drafted and then send it to opposing counsel to approve and then submit to the court.
Okay, thank you. Is there anything else?
Not for me, Your Honor.
Not for me.
All right, that concludes this matter. Have a good weekend.
Thank you so much.
You as well.
Seth, who's next?
Williams v. Progressive.
Okay, you could bring him in. Good morning.
Good morning, Your Honor.
Madam Clerk, whenever you're ready, please call this case.
Calling case number 25010-005, Williams versus Velasquez et al.
Your appearances for the record, please.
Good morning, Your Honor. Trish Klein on behalf of defendant, Progressive, and Velasquez.
Good morning, Your Honor. Kennedy Taylor appearing on behalf of intervening plaintiff AS Medical. Good morning, Your Honor. I'm on behalf of intervening plaintiff CET Pharmacy.
Good morning. All right, this is the defendant's motion to dismiss the intervening plaintiff.
That is correct, Your Honor. AS Medical Group.
You may.
Thank you, Your Honor. This is our motion to dismiss for violation of the court's June 17th order, or alternatively, to dismiss intervening plaintiff's claims related to the nerval matrix treatment. Your Honor, we've been attempting to get the deposition since March of 2026. This has been an ongoing issue. We have obviously filed a motion which resulted in the June 17th order, which was necessitated based on the fact that we attempted multiple times to get a date for this deposition. The court order was very clear. It said that the parties had 7 days in which to mutually agree to a date. That would have put the deadline by June 24th. And then the deposition was to take place pursuant to the court's June 17th order. The deposition was to take place by July 8th. And it has not taken place, Your Honor. So at this time, we think that pursuant to the Dean factors, dismissal of those claims is warranted, or alternatively, dismissal of the nerval matrix treatment.
All right. What's going on? Because I see the response, and in the response, the claiming that intervening plaintiff is claiming that they've been trying to schedule it, but there was the doctor's wife was having a baby.
That's correct, Your Honor. We had a date chosen for July 21st, and that date was mutually agreed upon between all the parties prior to defendant's motion to compel the death of the doctor. Once that order was granted and the timeline to get the deposition completed was moved up, all the parties were diligently working together to secure a date. Unfortunately, the doctor's wife was set to deliver a child in that same week or 2 weeks that we were supposed to get the deposition scheduled. So we did reach out to defendant's counsel on, I believe, July 27th to try to get a date, and we received no response at that time. I have confirmed with Dr. Ali that his child is here now, and he is willing to do the deposition. So if the court is inclined to allow additional time, we would ask that defendant's motion be dismissed and that we can get a new date for the deposition to take place.
Were you aware of the situation with the doctor's wife? That's a question for defense counsel.
Thank you, Your Honor. We were, but again, following the court's order on June 17th.
Yeah, but hold on, pause.
Sure.
I issued that ruling without a hearing, just looking at the pleadings and the circumstances and thinking that that would be a reasonable amount of time. But I had no way to know the life circumstances of the witness's wife and a baby. I mean, are you serious right now?
Well, Your Honor, to be
Why
fair,
wouldn't you, hold on,
okay.
why wouldn't you, if they made you aware of the situation with their witness's wife having a baby, why wouldn't you afford them some grace? I understand that litigation is an adversarial process, but you don't have to be unnecessarily adversarial with each other. And if life circumstances made it impossible for them to comply with the court's order, I have a concern with you coming back to the court asking for this type of potentially dispositive relief and not conducting yourself with full candor to the court, which you're ethically obligated to do, to make me aware that you knew that there were life circumstances that may have been preventing the intervening plaintiff from complying with the court's order.
Go
Well, ahead, you know.
Your Honor,
Yeah.
I will state that we did not know about the wife being pregnant until June 25th, which was already after this court entered the order. So when we requested, Your Honor, it was in good faith. We had absolutely no knowledge of the pregnancy until June 25th. So at that point, the deposition was already supposed to be scheduled.
Here's what I want you all to do. I want you to go in a breakout room. Seth's gonna put you in a breakout room. And I want you all to talk to each other and agree on a mutually agreeable date for this deposition that you can put on the record, okay?
Your Honor, may I just ask a question? I looked right now, I don't see plaintiff counsel. And they were also,
You're trying to depose the intervening plaintiff's witness, right?
yes, Your Honor. And my
Okay.
question was going to be, if plaintiff counsel is going to be a holdup, is it all right for the parties that are here to just commit to a date? Because the last time we agreed to a date, plaintiff's counsel said they couldn't do that date.
Well, if plaintiff counsel wanted to be heard on this issue, plaintiff's counsel should have appeared for this motion.
Okay, thank you, Your Honor. That's all I
Okay.
needed to hear.
All right. So you all go in a breakout room and talk about this and come up with a date, okay?
Okay, perfect.
Thank you.
All right.
Thank you.
And we're bringing the next people.
No, hold on just a second. Give
Okay.
me a minute. Are y'all ready?
Yes.
Okay. You've had
We
a chance to discuss this matter, and you're prepared to agree upon a date for the deposition?
That's correct, Your Honor.
Okay, you may.
We are going to take the deposition of Dr. Ali Shakur on August 28th at 1 p.m. via Zoom.
Right. Now, unless there's good cause for this deposition not going forward, failure for the witness to appear on that date and time may result in the claims related to that doctor's alleged treatment to be dismissed from this case.
Understood, Your Honor. Thank you.
And plaintiffs' counsel just has to get in where they fit in. I mean, if they wanted to be heard, they should have come here today. All right, y'all have a good weekend. Don't be fighting about stuff like this.
All right. Thank you, Your Honor. Have a
Your
good
Honor,
weekend
I
as
just
well.
mentioned, I said, once us ladies got together, we sorted it out really fast. So maybe next time. we're
It's Zoom. It's because people don't see each other in person and you can't resolve stuff like this. If you were bumping into each other in the courthouse and at Caseyville, you could talk and sort this kind of stuff out. Also, I want to tell you that sitting to my right is Judge Paul Cusick, who is rotating over from the criminal division and taking over Judge Hughes's docket. He's been on the bench for 10 years. He's a good friend of mine, and he's going to be a great addition to the civil bench. So he's just here watching motion call so that he can get up to speed on how some things function in the civil division.
Well, we're excited to appear in front of you, Your Honor.
He said thank you.
Definitely. Nice to meet you.
Nice to meet you, Your Honor. Well, thank
All
you.
right.
You.
All right, y'all have a good weekend.
Thanks, you too.
All right, you as well. Take care.
Seth, who's next?
Hamid versus Mimic.
Good morning.
Good morning, Your Honor. Jennifer Surek appearing for
The
defendant
case has
Mimic.
not been called.
Oh, sorry, Your
I
Honor.
just said good morning to try to get everybody to turn their cameras on.
Sorry, Your Honor.
Is this everybody we need for this motion? Uh-oh, what's happening?
I haven't received a response from the underlying patient, Your Honor.
Mr. Dowdy, can you hear me?
I can, yes, Your Honor.
Oh, okay. You ain't say nothing, so I wasn't sure your audio was broken. I didn't say good morning just to say it. I said it because I wanted you to respond so that I could know if your technology was functioning.
I was stepped down the hall and I heard noises, so I just ran back. I'm sorry I didn't hear you. Good morning, but
Okay.
so I'm not winded though. That's good. Good morning to you.
Good morning. Okay, so this is
for what it's worth. I texted Mr. Baghdadi asking me if he's going to appear. He hasn't responded to me
he's the
either.
one that responded objecting, is he not? Somebody responded objecting, which is why this got set for a hearing.
Oh, we not objected to the distribution that it be dismissed without prejudice because it's a cap and our claims are higher than the cap. So we want to
Oh,
roll
okay. Let's just go. If
right.
he's not here, then that means he don't want to be heard. He didn't file a response. So, Madam
Right.
Clerk, please call this case.
Calling case number 250104559, Hamid versus Mimic Insurance Company.
Your appearances for the record, please.
Michael Dowdy on behalf of Finish Line.
Good morning.
Good morning, Your Honor. Jennifer Surek on behalf of defendant Mimic.
Good morning. Whenever you're ready, you may proceed with your motion.
All right. Thank you, Your Honor. This is our motion for 3112 or equitable apportionment. We have a few cases regarding this patient and this claim, but there are only $29,636.04 remaining. under the policy. It's a case where there's just a $50,000 limit, but we currently have $77,524.26 in medical bills. So right now we have non-opioid relief filing their own case in district court. They have not objected to this motion, but I have let them know, this is just an equitable apportionment situation. And we have Finish Line Physical Therapy who is here. They have, I want to say $63,434.26. So they would get a larger percentage of the apportionment since their bills are higher.
Are you there?
Yep.
Me?
Were you done?
Oh, yes. That's
Oh.
basically my position. I just wanted to see if, Finish Line had anything they wanted to add.
All right.
Would you like me to go ahead?
You may.
All right, thank you, Your Honor. And thank you, Jennifer. The only caveat that we ask is that because this is a distribution of a medical cap and it doesn't satisfy the claims that we are presenting, that the dismissal be without prejudice because there is a excess economic claim that will roll over into an uninsured, underinsured claim. And if we're looking at the police report, the other vehicle who's at fault it looks like it's uninsured. So I'm not. So I don't want to extinguish that ability for my client to, follow the remaining balance of our claims under that umbrella of uninsured policy for excess economics.
Do you have any rebuttal to what his argument is?
I have no objections to that, Your Honor. We could have this be without prejudice.
All right, your motion will be granted. I do believe that you indicated that you put all the interested parties on notice of today's proceedings and no one's appeared here and placed any objections. So your motion will be granted. Submit the order, I'll sign it.
All right. Thank you, Your Honor.
You're welcome. Have a good weekend.
You too.
Thank you very much. Sorry earlier. Take care.
Ready for the next one?
Yes.
Okay. It's Polk v. Progressive. It's a motion for show cause.
Thanks. Good morning. Good morning.
Good morning, Your Honor.
I apologize. I have Judge Cusick sitting with me today. He is rotating over from the criminal division and taking over Judge Hughes's docket. So I was just answering a question for him. Thank you for your patience.
Oh, no problem. Good morning, Your Honor.
Madam Clerk, please call this case.
Calling case number 25010-510, Polk versus Progressive.
Your appearance for the record, please.
Good morning, Your Honor. Daniel Zittner appearing on behalf of the defendant Progressive.
Good morning. This is the date and time set for your show cause hearing. You may.
Yes, thank you, Your Honor. I believe this is our motion to show cause today. Various providers in this case. Via our record retrieval service, we issued valid subpoenas to several different providers in this case. I believe we have 5 listed in our motion, and they were duly served via certified mail on each of those entities. One of those entities has since produced records, billing, diagnostics, but the records for the other 4 are still standing. So we're just looking for an order today to compel those entities to produce the records within a certain time frame.
So what are you asking me to do?
Your Honor, if the court would be so inclined to compel these entities listed in our motion to produce the records within 14 days.
But today's the actual show cause hearing, isn't it?
Oh, Your Honor, I have it
Oh,
as
it's
the
the motion
motion.
for show cause.
Yes, yes.
Right. The show cause hearing date is going to be the same as the other case, Kim? The 20. Did you say the 20? Oh, that's why Seth was asking. That seems like a long time. I think we should keep that September date and then let the people that are just doing show causes come on Zoom like I. Okay, so here's the thing. September 25th, I'm returning to I'm going to start once a month having in-person motion call. So September 25th is going to be your show cause hearing date, but you're not going to have to appear in person, okay? If you don't have the records, you'll be able to just come on Zoom.
Okay.
So the records will need to be produced by, what did I say, September 11th to the, I'm sorry, Officer Carver, can you hold that calendar up again? Yeah, the records will need to be produced by September 11th. If they fail to produce them by September 11th, then they'll have to appear before the court on September 25th to show cause for why they should not be held in contempt. And
Sounds
just
good, Your Honor.
remember, I told you you don't have to appear in person. So when you get the notice that we're going to sort out the details of how we distinguish who has to appear in person. But remember, I told you you don't have to come, okay?
Okay. Thank you, Your Honor. Appreciate it. I'll submit an order.
All right. Have a good
Okay.
weekend.
You too.
Seth, who's next?
Scream the Powers versus Citizens and Powers v. John Doe. It's 2
Oh,
separate
yeah,
case numbers.
they got like 5 motions.
2 motions each case, yeah.
Powers.
I think some of them resolved though,
Okay, bring them in.
but bring them in.
Good morning.
Morning, Judge.
Good
Is
morning.
this everyone we need for this motion?
Yes, Your Honor.
Okay, y'all had like 5 motions that were up today. Have any of them been resolved?
So, Your Honor, this is a motion in this case, and there's a related case called the Cream Powers versus FedEx, and I think they should be joined because it's a different case number, but one of them is to consolidate this case with that one.
Yes, good
Okay, but
morning, Your Honor.
Oh, there she
do we
is.
have everybody?
I believe so, Judge.
Okay, so can y'all answer my question? You had like 5 motions that were up today, and have any of them been resolved?
No, Your Honor.
No.
Okay. Madam Clerk, please call this case.
Calling cases 25012-293, Powers versus Citizens, and case number 25014-016, Powers versus John Doe et al.
Your appearances for the record, please.
Yes, good morning, Your Honor. Mike Pisetsky appearing on behalf of the plaintiff.
Good morning.
Norma
Good-
Gann on behalf of defendant citizens.
Emily Bain on behalf of defendants Federal Express, Adept Courier Express, and John Doe.
Good morning, everyone. I also want to indicate for the record that Judge Cusick is here with me. He's rotating over from the civil division, from the criminal division to the civil division and taking over Judge Hughes's docket. So he's just sitting with me today to get the lay of the land here in civil. Okay, so he said good morning. Y'all can't hear him, but he said good morning. All right. Where you want to start? There's a lot of motions. Which one you want to start with?
Yes, Your Honor, I think the first motion to compel can be handled pretty quickly if that is acceptable to the court. So first, the plaintiff has no valid basis to refuse to appear for a properly noticed videotaped deposition. The court rules expressly permit audiovisual recording. So defendants Federal Express properly noticed the plaintiff to appear for a videotaped deposition. The plaintiff then filed a motion for a protective order. The plaintiff never properly noticed a hearing for that deposition. And so the deposition was scheduled. I repeatedly contacted plaintiff's counsel's office and never heard a response. I called, I emailed, nothing. And it wasn't until approximately 7 p.m. the night before the deposition did an attorney from that office, not the attorney of record, finally respond to my dozens of communications that the plaintiff would not be appearing due to their motion for protective order. And so plaintiff's non-appearance was not substantially justified. And counsel's conduct was particularly egregious because they repeatedly obstructed the deposition process by delegating substantive attorney responsibilities to administrative personnel who could not confirm whether or not plaintiff would appear. So I'm requesting two things. First, an order compelling plaintiff to appear for a properly noticed video recorded deposition. Plaintiff's claims that it would be abusive and intimidating to record him are baseless. There was no factual support for such a claim, and so we're requesting that order accordingly. And we're also seeking sanctions in our costs for late canceling our court reporter.
Okay, but you had reason to know, given that they had filed that motion, that the deposition wasn't going to go forward. Did you not?
However, a motion for protective order is not the same as an actual protective order preventing
I know
the
it's not. I know
deposition.
it's not, but you would agree that you were on notice that the deposition was not likely to go because opposing counsel, by way of filing the motion seeking protective relief, it would have you had reason to know that debt wasn't going to go.
I had been contacting them for weeks. They filed that weeks in advance, and I could not get any response from anyone at that law firm as to whether or not they were going to notice that motion for a hearing and actually schedule one. It was only after I contacted your clerk, Your Honor, that was it evident that they had not actually scheduled the hearing, or was I able to speak to an attorney at that law firm to confirm whether or not they were producing their client.
Okay.
Your
I'm
Honor,
going to let
Your Honor,
counsel respond,
yeah,
and then
Judge. I'm sorry, Judge.
I'm going to let plaintiff. May I speak?
Yes, Your Honor.
Thank you. I'm going to let plaintiff's counsel respond in a moment, but I'm having trouble finding your pleadings. Which case was this motion filed in?
Yes, Your Honor. It was case number 25014-016-NI, and this was I'm so sorry. That is the incorrect number that I just gave you. This is the Cream Powers versus John Doe, and that's 25014-016.
Okay, hold on. And which day was your motion filed?
My motion
There's so many
for,
motions, it's hard for me
yes,
to find them all.
and I apologize for that, but the reason there's been so many motions is the lack of communication with plaintiff's counsel
You
and the
don't have to fire
consistent.
no more shots. Just
Sorry,
tell me
I
to
will. Yeah, we keep needing to adjourn the scheduling order because we haven't been able to prosecute this case. I will tell you the date. I apologize.
Yeah, because you're just gonna keep on saying what you want to say. And
Yeah.
all I want you to do is answer my question so I can find the pleadings.
Yes, Your Honor, I apologize.
I found plaintiff's motion for a protective order, but I can't find your motion.
Our motion to compel was filed June 23rd, 2026.
I'm sorry, I was talking to my clerk. What day did you say the motion was filed?
June 23rd, 2026. Would it be helpful if I uploaded it into the chat?
Mm-mm. So the issue is, no, I have it. The issue is you're talking about a deposition, but the motion is captioned as a motion to compel initial disclosures and discovery responses. So that's what's throwing me off a little bit. Was there a motion regarding the deposition?
At page number 11, we discussed the plaintiff's failure to appear at the deposition.
Okay. All right. So do you want to say anything about the initial disclosures and the other stuff, or?
Regarding the initial disclosures, they are deficient in many ways. Um,
You okay?
yes, sorry.
All right. Let you gather yourself and your thoughts about the rest of your relief you're seeking, and I'm gonna go ahead and let plaintiff's counsel respond about this deposition, okay?
Thank you.
Thank you, Your Honor. What hasn't been indicated by counsel is that along with the motion for a protective order, unequivocally stated, there was an objection to the videotape deposition, clearly marked, clearly identified. Not only did we file the objection, we then filed for the motion for protective order. So come
But your
before.
motion for protective order was never precipitated, so it never got scheduled.
Okay, well, Judge, I guess we're talking about, because counsel brought it up, we're talking about notice to them. Not only did they receive a motion, they also received an objection to the deposition. And Your Honor, I believe that this is not the first time that the court has seen a motion for a protective order, because I do believe it's an attempt at intimidation and harassment to have an in-person videotape deposition. I understand that there are certain cases that might require a videotape deposition, such as a brain injury matter. But in this type of case, Your Honor, it is a routine type third-party case, and there is simply no reason for a videotape deposition to occur. It is simply just an attempt to harass. And this is not the first time I've seen people try to do that, try to notice it up depositions, video.
All right. Is there anything else you want to say? about the deposition?
No, Your Honor.
What about all the other discovery issues? You want to say anything about that?
Well, I haven't exactly heard what her position is. I can tell you that the initial disclosures identify 20 different doctors, and then the interrogatories that were filed, answers to interrogatories, identify 22 different diagnoses. So it's considering that this is a third-party case, I'm not sure what can be deficient when all those matters have in the early stages of discovery been identified.
Okay. You want to respond now, Ms. May?
Yes, Your Honor. I just want to first respond to the videotaped deposition issue. The burden is on the plaintiff to prove that there are reasons that it should not be videotaped. Videotaping is allowed by the Michigan court rules, and there are no medical limitation, undue burden, harassment, expense, or improper conduct on the part of the defendants. Regarding our other requests, plaintiff has not identified any social media accounts, fitness tracking devices, or any other methods of electronic communication as requested. We have stated in our briefing that plaintiff maintains active social media accounts. We have proven under the Tompkins standard that there are discoverable information that plaintiff must overturn his social media accounts because it's relevant to his injuries and his claimed damages. He also failed to produce any photographs, videos, or other visual depictions that are relevant to his injuries and physical conditions. As plaintiff's counsel just stated, he has 22 different diagnoses. All of these depictions, social media posts, are directly relevant to his claims.
Okay. Is there anything you want to say on behalf of plaintiff now that you've heard about the social media accounts in particular?
Well, Judge, they obviously already have access to it. It's not private. You know, if they want to look at it, if they want to question him upon it when his deposition does occur, that's fine. I really don't know what it is that they're looking for.
They're looking for a disclosure of all of his social media accounts. They may have found one or two that were public, but they're looking for you to disclose every and any social media account your client has.
I can do that, Your Honor.
Okay. I think that the requests by defense counsel are reasonable. And so I'm going to grant both the motions. I'm not hearing any valid reason why they shouldn't be allowed to videotape the deposition if they want to. If it was on Zoom, it would be recorded, wouldn't it? Video recorded, wouldn't it? And most depositions nowadays are being done on Zoom. So they can record this deposition if they want to. The plaintiff has not satisfied the court that it would be unduly burdensome or there's anything inappropriate about the request. I want you all to identify a mutually agreeable date within 7 days for this deposition to occur within 21 days from the entry of the order. I also want plaintiff to supplement the responses to the initial disclosures within 14 days. As for the motion to consolidate, the cases certainly should be consolidated. That makes sense. But if somebody has an objection they want to place on the record, I'll let you state that now.
No objection, Your Honor, from plaintiff.
No objection from
Hearing nothing.
citizens, as we have a
Okay,
motion
great.
pending to consolidate as well.
All right. So, my clerk is going to give you all a Zoom status conference when you can appear and make sure all the interested parties are present to get the case on a scheduling order that complies with both cases. The date for that Zoom status conference will be what day, Madam Clerk? August 19th, you guys. On Zoom, just to meet with my clerk so she can get you all together on the scheduling order. Because I
Time,
don't have
Judge?
time to do with that right now.
Time, Judge?
What time, Kim? She said 9 o'clock.
And Your Honor, could we also include in that order then to adjourn the upcoming case evaluation in the case of the citizens?
Kim will deal with all of that when you guys see her on the 19th.
I believe that the hearing on the case eval is before the 19th. I think it's maybe Tuesday.
She'll notify case eval.
Okay,
Okay.
thank you.
All right, you guys will see Kim on the 19th and she'll get your new scheduling order all situated.
Thank you, Judge.
Your Honor, I really apologize, but just to confirm, the motion to compel is granted in full.
Yeah. I said they have 14 days.
Thank you so much. Appreciate it.
Okay.
Thank you,
Y'all
Your
have a
Honor.
good day. Seth, the parties on the trial are here, are they not? I thought I heard them.
Yeah, I was wondering who those, they all just joined, it looks like.
Yeah, bring them in.
Okay. I think it's, oops.
Good morning.
Good morning.
Morning.
Do we have everybody that we need for this?
Well, I'm here and my clients, the Walkers, are here. I can't see the whole list on the.
Good morning.
Okay, yeah, we got everybody. Mr. Stewart,
How are you?
have you heard from your client?
Unfortunately not, Your Honor, and I took your advice. We even had a process server go down there on Wednesday, knocked on the door.
Okay,
And
let's
posted.
call the case so this can go on the record.
Thank you.
Madam Clerk, please call this case.
Calling case number 19012-453, Violet Road Trust versus Dubach et al.
Appearances for the record, please.
Good morning, Your Honor. Trevor Stewart appearing on behalf of the plaintiff, the Violet M. Rowe Trust.
Good morning, Mr. Stewart.
How are you, Your Honor?
I'm good. Thank you for asking.
Good.
Your Honor, Thomas Assorti on behalf of the defendant Walkers, who are also present via Zoom.
Good morning, Mr. Assorti, and good morning to your clients.
May it please the Honorable Court, Gerard Scanlon, P number 74992, appearing on behalf of Mr. Dubach, who's present via Zoom as well, Your Honor. Good morning.
Morning, Mr. Scanlon, and good morning as well to your client. This is the date and time set for an adjourned Zoom final pretrial conference. The parties were before the court earlier this week for a final pretrial conference, and all of the attorneys appeared without their clients. And I have reason to believe that there was some difficulty with plaintiff's counsel communicating with plaintiffs. And so I adjourned this matter till today via Zoom to give everybody an opportunity to appear with their clients, and indicated that if anyone failed to appear without their client, that there would be dispositive relief against the person who failed to produce their client. So, Mr. Stewart, your client's not here Please make the record of your efforts to communicate with your client and secure your client's attendance for today's proceedings.
Thank you, Your Honor. As it relates to today's effort, we've called the client post our in-person hearing on Tuesday. We've even sent a process server down to his last known address in Rockwood. That process server attempted service on Wednesday, the 12th, did not reach the plaintiff. The process server then tacked our correspondence to the door of that residence, and that correspondence informed the plaintiff to attend today's Zoom hearing, or else the matter would be dismissed. And I still have not heard from the client as of today at 11:09 a.m.
This has been an ongoing lack of communication between you and your client, such that you also have a motion to withdraw as counsel that is pending before the court. Is that correct?
That is correct, Your Honor. We filed an emergency motion to withdraw this past Monday. In that motion, we outlined the efforts relative to our attempted communication since July 22nd, when we were here the last time for a pretrial conference in front of you, Your Honor.
Thank you.
And all those efforts have not been responded to by our client.
Okay. Given that the plaintiff has failed to appear today, do either of the defendants have a motion?
Yes, Mr. Sordi. Go ahead, Mr. Sordi.
Yeah, Your Honor, on behalf of the Walkers, and I'm sure Mr. Scalen's going to join me, we're going to ask that this matter be dismissed. In this case this is the second case now. This matter's been going on for 10 years. We indicated last time around that it's clear that the individual who is the trustee of the trust hasn't been at the house. The house hasn't been habitable since at least February of this year, probably earlier than that. So we're going to ask that the case be dismissed. And honestly, I'm going to ask for sanctions, not against plaintiff's counsel, but against plaintiff individually.
I concur, and I renew my request. The last time that we were in front of you, that the matter be dismissed with prejudice. I mean, this is the second time around here with this case that this gentleman has had the opportunity to refile. I think a dismissal with prejudice is warranted, and I think cost and attorney fees should also be awarded to both defendants' counsels.
All right. Any response on behalf of plaintiff's counsel?
Your Honor, I don't believe that. And again, if you want to address the request relative to sanctions and otherwise, I believe that should be done pursuant to a motion along with proper authority given to this court. At this time, I don't think that it's ripe, nor is it in front of you. However, I believe that you do have the discretion to dismiss the case given the lack of the plaintiff's failure to appear. So I'll leave that to your discretion, Your Honor. You understand my position, and it's been outlined on the record of my lack of communication with the plaintiff, not based on our failure, but on his failure to respond to us. I don't believe that the case has been adjudicated on the merits, so I don't believe that it should be dismissed with prejudice. But I do believe that I don't believe I will leave it to your discretion to dismiss the matter.
All right. The motion to first of all, your motion to withdraw is going to be granted. And in the order allowing you to withdraw, you should include your client's last known address, email address, and phone number.
He does.
Additionally,
He did not have an email address, Your Honor, just to make that clear.
Okay. Additionally, the motion to dismiss is going to be granted. Is going to be, however, a dismissal without prejudice. The court does not believe that I have any authority to dismiss with prejudice at this juncture. Further, any motions for sanctions or costs need to be the subject of a separate motion that the court can evaluate on the merits. I am not granting any cost or sanctions at this juncture, but I'm not foreclosing it as an option for the defendants upon a properly filed and notice motion.
Thank you, Your Honor.
Thank you, Your Honor.
All
Would you
right.
like us to prepare that order?
Yes.
Have a great day.
Thank you. Take care.
Just so I'm clear, Mr. Stewart's preparing the order, right?
I will, Tom. Yeah.
Okay.
Yep.
All right. Thank you.
Thank you. Take care.
All right, this case is dismissed without prejudice. Who's next, Seth?
Easterling, that's 2 cases as well. Number 8.
Good morning. Do we have everybody that we need?
I believe we do.
All right. Madam Clerk, whenever you're ready, please call this case.
Calling cases 25012-873. I'm sorry. The case number is 25012-876. Easterling et al. Versus Farmers et al. And case number 25012-877. Yarborough versus Farmers.
Your appearances for the record, please.
Good morning, Judge. My name is Frederick Plum. I represent the defendants Brian Morrison and Ruby Weathers.
Good morning.
Good morning.
Good morning, Your Honor. Trevor Katona appearing on behalf of defendant Farmers.
Good morning.
Good morning.
Whenever you're ready, you may proceed with your motion.
Both of us have motions, Judge.
Okay, which one you want to do first?
Well, I have a motion to compel discovery from plaintiff, which I'm withdrawing because I got all the discovery I need this week from plaintiff counsel.
Okay, great. That's music to my ears.
Yeah, and I have a remaining motion just to adjourn the scheduling order 60 days. I don't think there's any objection to that. These are 3 cases all combined under one controlling
The
case
person
number.
with the objection might be the lady with the black robe.
I'm sorry, Your Honor. We have outstanding discovery from some medical providers and Social Security Administration.
What track
And
are you on?
I think 2, although I don't have the track in front of me.
Can I ask you a question? Why can't
Yes.
we just extend discovery 60 days? Why do we need to move the whole track?
We can do that.
Okay.
That would be acceptable.
I will expand discovery for 60 days, but keep the case on track too.
Thank you, Judge.
Anything else you want in that
I do
regard?
have a motion to show cause Social Security Administration because they have not provided me with records on Ms. Yarborough.
Okay, the
I
records will need to be produced no later than September 11th. If they fail to produce the records by September 11th, they'll have to appear before the court on, what's that date, Kim? September 25th to show cause for why they should not be held in contempt of court.
Thank you, Judge. That's all I have today.
All right.
All right. So I have 2. So there's a motion for leave to file a third-party complaint, and then there's also a motion to show cause James Wingate. These 2 issues are kind of related. I believe I can address the show cause hearing for Mr. Wingate first. So this court granted defendant's motion to show cause Mr. Wingate on July 28th.
Remind me again who Mr. Wingate is.
Yes, Mr. Wingate is the owner of the involved motor vehicle in this accident.
Okay.
He was not, we don't, so all right, so we've been trying to obtain his deposition testimony. After that order, we attempted to serve him with it, personal service, but that failed. We did serve him certified mail. He had a deposition that was scheduled that he did not appear for. However, because we didn't serve him personal service, and I don't believe there's any order allowing alternate service in this matter, I don't believe it would be appropriate.
Yeah, because alternate service is not going to accomplish your goal. Your goal is to actually have them deposed.
Right. So,
Are you trying to ascertain whether or not there was any insurance coverage on this vehicle? Is that what this issue is?
I believe that's the primary issue. We also just wanted information regarding like whether there's permissive use of the vehicle, issues like that as well. So at this time, I don't believe it's appropriate or permitted to hold him in contempt of court because of that failed personal service.
Okay, so what you want to do?
So with that, I would say we could, hold off on that and I think this second motion, the motion for leave, I believe will ultimately resolve this issue. So defendant farmers also filed a motion for leave to file a third-party complaint against Mr. Wingate. And so because we believe he is the owner of the uninsured motor vehicle, there are farmers will, if that is the case, we would like to file a complaint against him because as an owner of the uninsured motor vehicle under MCL 53177, he would be liable for all benefits paid by the insurer farmers. So we're going to have to file a suit against him anyways. We believe it would be prudent for the court to permit us to file an amended complaint and just bring him into the suit.
Do you have any likelihood that you would actually be able to serve him with it, though? It seems to me like you're likely to just end up seeking a default against him because you won't be able to serve him.
That might be the case, but I don't believe that should affect the court's ruling on whether we are able to file the amended
Futility.
complaint. Well, it wouldn't be
And the potential delay in this case that's already 359 days old. Because say you really do serve him and he does have a lawyer, then that lawyer might be wanting to adjourn everything and slow everything down.
Either way, we will likely be filing, or either way, we will file a suit, and then
It's just a
probably,
question of whether it's a part of this case or another one.
or if it's a separate case, then we would be likely filing a motion to consolidate. So this could actually, I believe, simplify the matter and just
So in
allow
other
us.
words, I am trapped by your legal maneuvers either way.
No comment as to legal maneuvering. I mean, I think this is the appropriate method too, and then this would also permit us to.
Okay. Is there anything you want to say before, in response to this motion to file the third party of the complaint against Mr. Easterling before the court rules?
Your Honor, I have no comment on this.
All right, the motion will be granted.
Thank you, Your Honor. I'll
You
prepare
got to
an
file
order.
that complaint within 7 days of entry of the order, though, to get this ball rolling, okay?
Yes, I will. That will be part of the order that I submit today.
All right. Is there anything else? Y'all had like 5 motions. 1, 2,
Oh,
3,
there was
4.
another motion to dismiss based on discovery, same issue that co-defendant filed, but we are also, I believe either we did withdraw it or we are withdrawing that motion as well because plaintiff did produce discovery.
All right. Is there anything else?
I think we're all set.
All right, I want to tell you that this gentleman sitting to my right is Judge Paul Cusick, who is rotating over from the criminal division and taking over Judge Hughes's docket in a few weeks. So he's just sitting with me today so that he can observe a little bit of what goes on over here in the civil division. He said, "Good morning."
Good morning.
Good morning, Your Honor. You're getting a master class today from the Honorable Judge Lillard.
He's a good friend of mine. Paul, you were my intern first in the prosecutor's office, weren't you? Yeah, he was my intern and then my colleague. I let you sit at my desk. Anyway, so he was an intern when I was a young APA, and then he became my colleague in the prosecutor's office, and we happened to share the same alma mater, the University of Notre Dame. So we're very close friends, and I'm very excited to have him join me over here in the civil division. I've been trying for a long time to get him to bid to come over here, and I think you will find him a welcome addition to this bench. And so this is
Congratulations.
Yes, congratulations.
congratulations. All right, you guys have a good day.
You as
All right,
well. Have a
take
good
care.
day and have a
Thank
good
you,
weekend.
Judge. Goodbye.
Thank you.
Seth, who's next?
Northland versus Cure.
Bring him in. You're back?
I'm back.
You have more than one motion. We should have did the other one when you were here.
They were just one apart, so.
Good morning, Mr. Bloomberg. I can't hear you. You're still muted, Mr. Bloomberg.
I'll take your word for it. Must be a great day, but it's not one good for me. But go ahead.
Oh, I'm sorry, Mr. Bloomberg. Take a few
Well,
deep breaths.
2.5 hours in this court, and I understand the circumstances. And then my 11 o'clock comes in, so I just signed off of that. So, hey, I have a firm belief, and I know Your Honor has a similar belief than me. This nonsense needs to stop. These hearings all need to be in court, not on TV, not on laptops or anything else. This court needs to operate from the bench, and these lawyers need to know that that's what it's like. Otherwise, I mean, I get sometimes 3 and 4 hearings. I'm not the only one. I know a lot of other attorneys. I know Ms. Gant is very busy as well. This needs to stop. That's my, I'm gonna say it to every judge I see. This is your only time, but I'm gonna say it to every single judge I see. This nonsense needs to stop.
Well, you know how I feel about Zoom. Madam Clerk, please call this case.
Calling case number 260000615 Northland Radiology versus Cure.
Your appearances for the record, please.
Good morning, Your Honor. Gary Blumberg on behalf of the plaintiff, Northland Radiology.
Good morning, Mr. Bloomberg.
Good morning, Your Honor. Norma Gann on behalf of Defendant Cure.
Good morning.
Good morning.
All right. Is this your motion today?
It's my motion.
Okay. You may, Mr. Bloomberg.
Thank you, Your Honor. I'm not sure if the court or how much the court recalls of this particular case, but we filed this case, and then the defendant sent out a check not identified by any EOBs, dates of service, or anything else, and then immediately filed a motion for partial summary disposition, claiming that the check paid my entire claim based upon what their quote unquote experts said, and therefore they were entitled to summary disposition. I opposed the motion for number one. I did not cash the check because I knew there was something wrong with sending out this check in this manner. And I have seen this by Cure in numerous circumstances, at least a few in my office, and I know I'm a small office, so they're doing it all over the place. So counsel for the defense at that motion was a different attorney, didn't have much of an explanation for what they were doing. My position was they should be sanctioned to try and trick a plaintiff's attorney to negotiating a check and then come in and argue that they paid in full based upon an expert before anything's even been disclosed at the very inception of the case. This court heard detailed argument on that motion. And after the argument, this court denied the motion for partial summary disposition and issued an order from the bench, providing that the defendant was to produce this quote unquote expert for deposition and produce the claim representative or person at Cure who had issued the directive to make these kinds of payments, the kind that was the exact one that was made here, that issued a directive to send it off based upon some quote unquote expert's report, et cetera, to allow me to explore that part of my claim. The court ordered that the defendant provide me dates for those two people, the claims person responsible for why we were there and the quote unquote expert within 7 days. And then the depositions were to be taken place within 30 days. Now, the court issued the order from the bench. One of the problems that we have now that we don't come into court all the time, another one of the problems is Wayne County, along with every other court, violates the court rule about entry of orders. They allow lawyers to file them as long as they were in Zoom on the date of the hearing. Hey, here's an order. Well, that's what counsel for the defendant did here. And counsel for the defendant issued an order without my approval. There's only three ways to get it. You either have my approval, you do it from the bench, or you file a motion for, under the 7-day rule. You can't just file it and hope it gets filed. But every county, every judge does it. It's a violation of the rules, and it causes exactly what occurred here. Counsel for the defense filed an order that said the motion was denied without prejudice. The court did not rule it was denied without prejudice. Counsel for the defense put that in there. Now, you could interpret, you didn't rule one way or the other on that. You didn't say it was with prejudice, without prejudice. You denied the motion. Counsel for the defense added that in there. And then put in there, it's further ordered that the depositions are to be scheduled within 7 days and the depositions are to take place within 30 days. What depositions? I know because it was my motion, my argument. It wasn't specified. It was submitted without my permission. I sent an email to counsel for the defendant suggesting to her as follows. Most importantly, you left out of the order that you provide me with dates for the deposition of your quote expert end quote and the claim person who authorized the issuance of the check which was the subject of your motion within 7 days, and that you produce both of them for depositions within 30 days. Further, Judge Lillard did not rule that the order was without prejudice. Your client's substituting a new attorney and law firm will not protect you from the ramifications of your conduct, which I believe was intentional and unethical. And I received a response back from counsel that I had no intent to submit a false order. Since the judge has already entered my motion, I will file an amended order to include the additional language about depositions. You can't just file an order. This was a week later. You can't do that. She did that. That order didn't comply as well. And so we're here today. But most importantly about that, forget the paperwork that shouldn't have been filed in the manner that was filed and was false. I was told within 7 days of June 23, I was to get dates for those depositions. That date passed. I was told the depositions were to take place, and counsel for the defense, then counsel for the defense, was there to hear it all. And she doesn't even dispute that in her email. They were to take place within 30 days. It's August 14. This was June 23. I don't have a deposition. Now, not only don't I have a deposition, but they hired new counsel. And not only did they hire new counsel, but they're barraging me with the most absurd motions I think I've ever seen. First, they file a motion for reconsideration. And a motion for reconsideration is merely to point out that they want you to order that, and this was filed on, get the date, July 22. And the nature of that, and although it says Heather Washington on the caption, it was, I believe, Ms. Gant who filed this motion. And the gist of the motion is that you should never have ordered those depositions. And therefore, there was palpable error because I hadn't noticed the depositions. No, I hadn't noticed anything. This was in the inception of the case. And the court permitted me to request orally that these people be produced well within your discretion, and you did. Now, we're waiting, still no dates for depositions. And believe it or not, this is what makes it so absurd to me. I get a couple of days ago, defendant's motion for protective order. And the motion for protective order says the court is well within its authority to grant a protective order to limit or bar the elicitation of deposition testimony or documentation from defendant's claim representative, Qiana Emery, as such would be a futile use of time, expense, and inconvenience for all parties. Asking for the same darn relief in their motion for reconsideration. They didn't call it a protective order. So now, despite what might be ordered here today, I got to answer another motion now for a protective order that I can't do what was ordered that the defendant do, that they have not done. Here's the most fascinating thing of the whole issue. They didn't answer this motion. They filed no answer to this motion. So now I'm going to request a ruling. I don't think defendant should be permitted to argue this motion. And then they get a motion for protective order. You haven't ruled yet on a motion for reconsideration. They're all the same thing. It's all a single issue. And yet, this is not a big case. They're making me run through hoops because, for obvious reasons, there's no other possible reason they are doing this, because they are afraid, and I don't mean counsel, I mean Cure, that I'm going to expose what they're doing in this program that I argued at the time of our hearing on June 23, and that I've talked about here this morning, this program of hooking plaintiffs into accords and satisfaction. And so here we are today, and I'm asking that the court set aside the order, both orders. I guess they've amended their order. I don't know, with an order that never should have been signed because it wasn't approved as to form. It wasn't sent out under the 7-day rule. It wasn't even done on the day that it was submitted. It was just some attempt to correct it. I want those orders set aside. I want the defendant ordered again, or reaffirmed, I don't know what you want to call it, to produce those people, that expert, and obviously the person they identified in their pleading that I mentioned, that is obviously the person who they're trying to protect me from cross-examining. And I want sanctions. I want to be paid an hourly fee for every hour I put in on this case from the time you issued the initial order on June 23 until today's date, and in the future for every hour, every minute that I spend arguing something that's already been ruled on by the court without any basis of doing it at all. And, you know, at the time of the June 23rd hearing, you reserved the issue of costs. That's not in the order either. And I don't expect you to remember everything, as many rulings that you make and hearings that you conduct. I don't expect you to remember that, but I remember it like it was yesterday, because it was so clear that they had no explanation for why they did what they did. And that's pretty much what counsel for Cure at the time said. And if, in fact, they're not satisfied with their representation, they don't get do-overs on things that have already been done because they substitute in another attorney. And so they don't get a do-over here. So I am requesting that the court reaffirm the order that they produce those people, that they produce them within 30 days, and that they give me dates available for these depositions within 7 days. These are things that were ordered 6 or 8 weeks ago, and that they pay my attorney fees for having to do this over and over and over again. Thank you, Ron.
All right, I understand and can appreciate your frustration, but let me give her a chance to respond, okay?
Thank you, Your Honor. The plaintiff did mention that there are other motions pending, and there's nothing improper about the motions that were filed and that are currently pending, but not up for hearing today. And that includes a motion for reconsideration regarding the deposition of the adjuster at Cure and the related motion for protective order. I think those are set for hearing on 8/28. There's nothing improper about asking for reconsideration under the situation
Let's get
where
to the real issue. The real issue, I think, is whether or not you all, you know, I said I was going to let you respond, and then I immediately cut you off in the middle of your response. But the issue that is most germane to me and concerning to me is the allegation that an order was submitted on behalf of your client that did not comport with the court's ruling. And I understand that the practice here in the Wayne County Circuit Court Civil Division is to have the lawyers prepare the orders. And I have a lot of cases, and I can't remember everything that I say in court. And so I trust attorneys to act in good faith and to submit orders that are consistent with what I have ruled. So we can talk about a lot of things, but the first thing I really want you to address is Mr. Bloomberg's assertion that there was some bad faith on your client's behalf, submitting an order that you all knew or should have known did not comply with the court's ruling. Please.
So, Your Honor, that order was submitted with Cure's prior counsel who attended the hearing. Unfortunately, I don't yet have the transcript from that, but as I understand, she submitted an order that denied the motion. She did put without prejudice, and there wasn't anything in an order about the depositions. That was something that was apparently raised at the very end of the motion. It was not in the motion, it was not in the response, was not in the reply. It was never requested, it was never briefed, nothing about that. Plaintiff then sent that email, part of which he read to you that he attached to his motion, demanding another order. And therefore, another order was submitted, which he could also have submitted at any point if he thought there was something that he wanted to add into that order. Instead, he threatens the sanction motions the first day. A new order gets submitted that does include about the depositions of, I've heard it two different ways. One, the person who issued the check or the person who authorized the issuance of the check, and the expert who wrote the report. And contrary to what was just represented to you, when I came into the case after I had returned from vacation, I did give him a date within those 30-day period for that expert. And then we did ask a reconsideration regarding the deposition. So we didn't include things in that order that was incorrect. Plaintiff also could have submitted an order relating to the depositions, but when we amended it, he didn't withdraw this motion. And when I talked to him, he was saying he really wasn't as interested in that deposition. He didn't accept the date I gave him, which was within the 30-day period, and said he's not even sure he wanted to do that, but he really wants to get something for another lawsuit from an adjuster about this. And I think he just alluded a little bit to that about, some plan or something he's talking about that there is for making a payment in other cases he referenced you. So his proper thing was to file a motion to say he objected to the order and produce a different order. I don't know what he wants in the different order because he never produced or suggested a different order to change the language. The second order
Okay,
seems
I'm
to
going
be
to stop you.
comply
I'm going to
with that.
stop you. Let me stop you. Because y'all are making my head hurt. And I say that with respect. I have to stop this. This is going too far. So here's what I'm going to do. Your motion for reconsideration regarding the deposition, which I think is pretty germane to this issue. I don't know what this is. Cancel. I'm trying to get back to my screen. I'm talking to myself. As long as I don't answer myself, We don't have a problem. Your motion for reconsideration was filed on July 22nd. I'm going to look at the motion for reconsideration and make a ruling on that on the pleadings today when I'm done with this motion call. I'm going
Okay.
to adjourn this objection to the order, motion to set aside, and the request for sanctions until I get back. And I'm gonna make you all come in person to address this. And I'm gonna see you all on Monday, the 24th. We have a trial cam that day. Yeah, I'm gonna see you guys on Monday, the 24th. And I'm gonna tell you what I'm gonna do. I'm off next week. But in between now and Monday, the 24th, I'm gonna watch the video to figure out who's telling me the truth. And I'm gonna be prepared to sanction whoever's not telling the truth. 9:30.
9:30, Your Honor?
Yeah, I'm gonna see y'all on Monday the 24th at 9:30 so we can pick this up in person. Okay?
Very good, Your Honor.
Okay, thank you.
Thank you.
In the meantime, stop fighting. Okay? And I'm gonna tell you that this is Judge Cusick sitting next to me. He's rotating over Mr. Bloomberg. I think I already introduced him to you on your last motion. But
Yes.
Mr. Bloomberg, this is Judge Cusick sitting next to me. He's rotating from criminal to take Judge Hughes's docket.
Good morning, Your Honor. It's nice to meet you, not necessarily under the circumstances that apply in
He
this
said, nice to
particular
meet you
case.
too. All right, y'all have a good weekend, and I'll see y'all on Monday the 24th.
Thank you, Your Honor. You have a good weekend.
Too. How far are we? How many more we got? Like
We
10?
got 3 more, and
Okay,
then
give me
defaults.
just a second.
Take your time.
All right, Seth, who's next?
Harvey v. State Farm.
Bring a man, please. Parties on Harvey versus State Farm.
Good morning,
Good,
Judge Lillard.
good morning. Thank you for your patience. Is this everybody we need for this motion?
Yes.
Madam Clerk, please call this case.
Calling case number 26001-573 Harvey versus State Farm et al.
Your appearances for the record, please.
Good morning, Judge Lillard. Good morning, Judge Cusick. Lisa Balua for the plaintiff.
Good morning.
Good morning, Your Honor. Paige Elshoff on behalf of defendant State Farm.
Good morning. Whenever you're ready, you may proceed with your motion.
Yes, ma'am. Today is the day that City Cab was to appear before Your Honor and show cause for violating this court's order. We appeared on July 15th, and this court ordered that City Cab should produce records on or before July 31st, 2026, or appear before Your Honor and show cause for violating your order. We have not received records to this date. We have received no communication, no objections, nothing. We filed a proof of service with this court on July 10th. That was the date of the hearing. I apologize.
Okay. What are
Telling
you
them about
asking
the order.
for? Are you asking for me to, are you asking for me to find them until they produce the records? Are you going to be seeking to dismiss something relevant to the case for their failure to produce the records?
We will be asking for you to find them, Your Honor.
All right, I'm going to assess a fine of $25 a day until the records are produced.
Thank you, Judge. And this is from today's date, correct?
Yes, ma'am.
All right. Any objections to that order, Ms. Isa?
No, Your Honor, we would ask that this be moved to track 2 if you would prefer us to
Oh, y'all
draft
can
a
have track 2.
separate
That's a
motion.
non-issue.
Okay.
You don't need a motion. You can stipulate to track 2.
Okay, thank you, Your Honor.
Okay.
Sure.
Is there anything else?
No, Judge. I'll get that ordered filed. Have a great weekend.
All right, you too.
Thanks.
Seth, who's
Thank you.
next?
I was muted. Hamilton v. Petoskey, alternative service motion.
Oh, okay, bring him in. This is the one with the lawyer, right? Let me look. Which case, Seth?
Hamilton v. Petoskey Place.
Okay, thank you.
Yeah.
Good morning.
Good morning.
Oh, well, it's afternoon. Oh, no, it's still morning. 3 minutes. Madam Clerk, please call this case.
Calling case number 26007-268 Hamilton versus Petoskey Place Limited Dividend Housing.
Your appearance for the record, please.
Ross Gilders appearing for the plaintiff. Good morning, Your Honor.
Good morning. This is your motion for alternative service. And I set this matter for a hearing because there's an issue with the attorney who is listed as the registered agent who has indicated to the process server that they are no longer the registered agent.
Would you allow me to share my screen where I could show you the diffs record for this entity where the attorney in question is indeed the registered agent?
No, because I believe you.
Oh,
The
well,
reason it's set for a hearing is because I'm at a loss for what we are to do. Because if she's no longer the registered agent, would she even have the ability to go into the diff system and change it? It would seem to me that as an officer of the court, I think what might be appropriate is for us to set some sort of a hearing for her to come and offer something on the record that supports that she is not the registered agent, because serving someone who's telling you that they're no longer the registered agent, is that going to be sufficient to effectuate service, because what you really want is service, right?
Yes, Your Honor,
So that's
and
why I said it for a hearing, so we could talk through on the record how we resolve this issue.
well, I think my job in this context here today is to do whatever you tell me. But I would direct the court's attention to MCR 2.105 D, and in that rule, in that subsection, it specifically, as you know, says that service or process can be completed on a private corporation. If you look at subsection 1, by serving a summons and copy of the complaint on an officer or resident agent. This attorney is indeed the registered agent. I find it
She's
hard.
still listed as the registered agent, but she
Well-
maintains that she has withdrawn as the registered agent. She's still listed as the registered agent.
And I think that
And you have a good faith, hold on. You have a good faith basis to believe that she's a registered agent because you're relying on the state's records. But if she is telling you she is not the registered agent, I want to see if she will come to court and say that. Because if, as an officer of the court, she appears before this court and indicates under oath that she is not the registered agent, I mean, you're attempting personal service, or perhaps we just need to seek another method of alternate service like publication.
Well, I think that would prove far less effective. And I would just also point out that the implication of such a ruling or such a practice could be substantially negative. Think about a reality in which anytime a corporate entity is served, oftentimes these registered agents and the principal owner of the corporation are the same. But imagine the implications of a practice where anytime, despite the realities of who is actually the registered agent, that anytime somebody indicates that they're not, or that they've wanted to withdraw or did withdraw, that you can no longer effectuate service in a meaningful way.
I understand what you're saying. I don't mean to cut you off, but I'm going to, because I understand what you're saying in theory, but the reality is this is a licensed attorney who is under an ethical obligation to conduct herself with candor to the court. You want to get service on this corporate entity. This practicing attorney has told your process server on multiple occasions that they are no longer the registered agent for this corporate entity. They withdrew, they resigned, and so I think that warrants inquiry by this court before I grant alternate service on her. Because if I just allow you to make alternate service with her, and she has in fact resigned as the registered agent, but the corporate entity hasn't filed the requisite paperwork to update the state system. I mean, I understand what you're saying in theory, but the reality is I cannot ignore what this affidavit of service says. And that is that this practicing attorney has told you on multiple, or your process server on multiple occasions, that they are not the registered agent. And you just want me to grant alternate service on that person. And I'm not inclined to do that without further inquiry into the veracity of her statements that she is not the registered agent. If it turns out that she is, in fact, the registered agent, fine. But what if what she's saying is true?
I do believe that the Department of Insurance, does the work for us by maintaining this record, but I understand the court's position, and I think it's logical. Not that my opinion matters, but I think your viewpoint is perfectly logical and not unreasonable. And so maybe if the court's not inclined to grant the relief that I think is, or I'm asking for, then maybe the appropriate course of action here is a show cause order with me required to file some sort of proof of service, and it's a show cause order for her appearance, and I need to file proof of service with the
Yeah,
court.
because I think she should be it should be a show cause for her to show cause why she's not accepting this service. Because you have a valid reason to believe that she is the registered agent and she should be accepting service of this complaint. And she should have to show cause to this court why she should not be accepting this service.
So I could draft an order that reflects that she's to appear at a date and time certain to explain why she's not accepting service on behalf of the corporate entity, despite the record appearing to be that she is indeed the registered agent. The order could just generally reflect that, and then you could
Yep. And the date for that is going to be Monday, August 24th at 10 o'clock. So we can get that done as quickly as possible. Okay.
and
It'll be on Zoom. Put some Zoom login instructions in there. And
I'll
she'll
put
need
that.
to appear on my Zoom and tell me why she's not accepting service.
Would gee whiz, could we possibly do 11:30 instead of 10?
Mm-hmm.
All right, I will make that 11:30. And I thank you very much for your help and the time, and I will submit that order right now and send it out for service immediately.
Okay.
Thank you very much, Judge. Have a great weekend.
You're welcome. You too. I'll see you on the 24th. Seth, who's next?
Robert Davis.
Bring him in, sir.
All right.
Parties on Davis versus Detroit Police Department.
Your Honor. Mr. Patterson's still joining, sorry.
Okay, great. Mr. Patterson, are you there? Mr. Patterson, are you there?
I am, Your Honor, and there. Yes, good morning, Your Honor.
Good morning. One moment. Well, it's afternoon now. One moment. Mr. Patterson, are you there?
I am, Your Honor, and
Somebody must have the YouTube open because I'm hearing feedback from YouTube. So if somebody has the court's YouTube open, if you could turn it off. Well, it's afternoon now. One moment. Mr. Patterson, are you there? All right, I think you all whoever has the YouTube on, you need to turn it off. I think it's Miss York. That's why I've muted you, Miss York, because it's creating an echo.
I don't see that I have any YouTube channels open, Your Honor.
I'm not hearing the echo anymore.
I don't
So
have
the
any
issue
YouTube
must be
channels open.
resolved. So anyway, thank you for your questions. I know you guys have been waiting quite a while to get your motion called, but I had a very heavy motion docket today, and I do the best I can to get through things as fast as I can. There was one case where the lawyers had 5 motions up. So I don't take any pleasure in making people wait over 3 hours to get their case called, but at least you're waiting in the comfort of your office or home instead of sitting here in court on hard benches like you used to do pre-pandemic. I understand that there have been some calls to my staff wondering when the motion was going to get called, but I'm doing the best I can to get through things as fast as I can without interfering with a party's right to be fully heard and address their issues. So I thank you for your patience. But the sheer number of motions that we had today, it took almost an hour just for my staff to get everybody checked in this morning. So I'm doing the best I can. I also would like to indicate to you all for the record that Judge Paul Cusick is sitting with me to my right. He is rotating over from the criminal division to the civil division, and so he's observing today's proceedings just to get an understanding a little bit of how things function in the civil division. So with that said, Madam Clerk, please call this case.
Calling case number 25013-283, Davis versus DPD et al.
Your appearances for the record, please.
Andrew Patterson on behalf of the plaintiff.
Tamara York Cook on behalf of defendants, Your Honor.
Right. Ms. York, this is your motion to set aside the default. And as I understand what happened here procedurally is the defendant filed a motion for summary disposition in lieu of an answer. And ultimately, this court ruled that that motion only sought relief on behalf of the defendant, City of Detroit, not the defendant, Detroit Police Department. And as a result of that, the plaintiff now moved for entry of a default because technically the Detroit Police Department is in default by failing to answer this complaint. And that is what brings us together today on defendant's motion to set aside the default. There's been no default judgment entered, just the default order.
Correct.
All right, you may.
Well, Your Honor, so the city initially takes the position that the default never should have been entered in the first place because the city submitted a motion for summary disposition 4 days before the clerk signed the default request. That's a substantial procedural defect, and for that reason alone, the default should be set aside. But even if you conclude that the default was properly entered, for the reasons outlined in the city's motion and brief in support, all the case law cited therein, the city has good cause and a meritorious defense that would entitle it to have the default set aside. Otherwise, the city
Okay,
rests
is
on
there
its
anything
brief.
else you want to say?
Otherwise, the city rests on its brief. I know that plaintiff is seeking costs and attorney's fees. Unfortunately, if the default was never properly entered to begin with, that provision is not applicable.
Why do you take the position that the default was never properly entered to begin with? I understand your position that the motion for summary disposition was filed before they moved to take the default, but is a delayed motion for summary disposition in lieu of an answer sufficient to avoid the timing in which your answer was supposed to be submitted?
As the city has outlined in its brief and its motion, which I rely upon, the city has absolutely otherwise defended the case before the default request was submitted and days before the default was entered. The plaintiff has not addressed the or otherwise defend aspect of the court rule at all.
All right, is there anything else you'd like to say?
No, Your Honor. We rest
All
on our
right.
brief.
You'll have a chance for rebuttal after plaintiff's counsel makes his arguments, okay?
Okay.
Your
You
Honor,
may.
may I proceed?
Yes, you may.
The court rules make it very clear as to when an answer or a motion in lieu of an answer must be filed, and they don't allow it to be filed whenever counsel feels like it. Default is properly entered for failure to answer.
The answer was due November 4th, 2025.
Correct. That's
Okay.
correct. That's correct. And that's the basis on which we've asked the clerk to enter the default. The default is also properly entered in that this defendant failed to appear. And although counsel initially appeared on its behalf, she's failed to file an answer or answer on behalf of the police department, and alleges that a 2001 executive order from Mayor Archer allows her to do that. Well, the substance of his order was repealed when the citizens voted in 2012 to amend the charter and make the police department independent of the mayor's office. And so her representation is a separate entity, as FOIA recognizes, and she's failed to respond in a timely manner to file an answer or a motion in that time frame. I would also point out to the court that if the court is allowed to allow her to proceed, the Court Rule 2603D4 explicitly requires, the court says it must award the plaintiff its costs and reasonable attorney's fees, as the court has discretion to do.
Okay, is there anything else you'd like to say?
That's it.
Your Honor.
All right, rebuttal.
Your Honor, the Court of Appeals case of Edmore versus Crystal Automation Systems says, and I quote, "A party must not be defaulted if the party has otherwise defended the action by taking some defensive action in this case." There's no question that the city of Detroit, once it became clear that the Detroit Police Department was not encompassed in the original motion for summary disposition in lieu of an answer, we had a motion for summary disposition filed the next morning. So we are clearly taking defensive action in this case. And the plaintiff's assertion that he's automatically entitled to costs and attorney's fees assumes that the default was otherwise properly entered. Costs incurred by the other party in reliance on the default is what must be entered, is what must be awarded, assuming you otherwise believe the default was properly entered. And attorney's fees are discretionary. And considering the timeline that I've laid out in my brief and all of the documents in support of that, there's really no plausible basis to conclude that the city wasn't otherwise defending this action before the default was entered.
Were you done?
Yes.
Okay.
The court rules dictate when answers must be filed or when motions must be filed, and that wasn't followed in this case. So you simply didn't follow the court rule.
My saying, "were you done," was for me to check to see if defense counsel was done. It wasn't an invitation for you to say something else, Mr. Patterson. Otherwise, we're gonna be like lamb chop. You know the song that never ends, just goes on and on. So
Appreciate it. Sorry, Your Honor.
I have the last word. It's her motion. Did you have anything else you wanted to say on behalf of the defendant?
No, Your Honor. Like I said, it's all outlined in our brief and our motion and brief in support.
Okay. Thank you for your arguments and your briefing on this issue. This matter is before the court on the Detroit Police Department's motion to set aside the default entered against it on August 4th, 2026. Having reviewed the motion and heard your oral arguments, the court is prepared to make the following findings. First, a clerk may enter a default only when a party has failed to plead or otherwise defend as provided by the court rules that as it's outlined in Michigan Court Rule 2.603A1. Additionally, the Court of Appeals has made it clear that a party must not be defaulted if has otherwise defended the action by taking some defensive action in the case. And that is the Village of Edmore versus Crystal Automation Systems Incorporated, which is 322 Mishap 244, a 2017 case. Wait, hold on. And a motion for summary disposition is a defensive action of that kind because it's an attack on the pleadings. And that comes from Huntington National Bank versus Rishick, which is 292 Mishap 376, a 2011 case. The Court of Appeals reached the same conclusion in a case where the defendant filed a summary disposition motion, but no answer, and was held not to have failed to otherwise defend. And that is Marpost Course versus AutoCam Corporation, which is 183 Mishap 166, a 1990 case. The record here shows that the Detroit Police Department filed a motion for summary disposition on July 31st, 2026 at 10:53 a.m. That filing preceded the plaintiff's request for entry of a default, and it preceded the clerk's entry of the default on August 4, 2026 by 4 days. Under those circumstances, the court finds that the Detroit Police Department had otherwise defended this action at the time the default was entered. Because the department had otherwise defended, the default was not properly entered under Michigan Court Rule 2.603D1. That improper entry constitutes good cause to set aside the default. The department has also stated facts showing a meritorious defense through its pending motion for summary disposition. Considering the totality of the circumstances, both requirements of the court rules has been satisfied. I've considered the plaintiff's arguments and find that they do not require that I find a different result. That the department's response to the amended complaint may have been due earlier doesn't really change the controlling question, which is whether the Detroit Police Department defended before the default was entered. Plaintiff's argument that the department submitted to the court's jurisdiction doesn't really defeat the motion because the motion is not grounded on a lack of jurisdiction over the defendant. As to costs, an order setting aside a default is ordinarily conditioned on the defaulted party paying the taxable costs to the other party incurred in reliance on the default. That condition presupposes a validly entered default that is set aside for good cause. Here, what I'm finding is that the default was improperly entered. Plaintiff obtained and relied on a default to which he was not entitled. And therefore, under these circumstances, I'm declining to oppose any costs or fees against the Detroit Police Department. And so the plaintiff's request for costs and attorney's fees is denied. So for the reasons stated on this record, the court is granting the Detroit Police Department's motion to set aside the default. The default entered against the Detroit Police Department on August 4th, 2026 is set aside. Any default related order entered against the Detroit Police Department is hereby vacated, and you all are going to proceed with the motion for summary disposition that is currently pending before this court. Seth, have you set a date for that yet?
Not yet, but if you'd like, I can give one right now.
No, you schedule it in the normal queue that you're scheduling your summary disposition motions.
Right.
Okay,
Okay.
I will do that.
All right, that concludes this matter. Again, I thank you so much for your patience. I'm doing the best I can to move through these matters as quickly as I can, yet still be thorough and afford everyone an opportunity to be heard. But I do appreciate your patience.
Thank
Thank you, Your Honor. I will have the order sent to Mr. Patterson later today.
Okay,
for his
thank you.
approval. Thank you.
You all have a good weekend.
Thank
You
you,
too.
Your Honor.
Seth, who's next?
It's Unifund LLC versus BA. It's technically a default, but there's interesting stuff. Bring him in. Oh, wait.
I'm sorry, Seth, what'd you say?
It's Unifund versus BA.
Okay,
He
bring
needs
him
to
in.
explain. Yeah, it's kind of complicated, but
Good afternoon. I can't hear you.
I was trying to talk into my little
There we go.
microphone here, but I had pushed a button and turned it off. So,
No worries.
good afternoon. Thank you for your patience.
Of course.
Is this everyone we need for the motion, Seth?
yes, Judge, it's default technically.
Oh, okay. Madam Clerk, please call this case.
Calling case number 1501130, Unifund CCR LLC versus BA.
Your appearance for the record, please.
Good afternoon, Your Honor. Kyle Glazer, P88827, on behalf of the plaintiff.
Good morning. This is your motion. You may proceed.
So, Your Honor, this is a very weird circumstance and a funky file on this case. Our office substituted in as counsel in 2026 on this case. This was forwarded to us on a judgment balance. We took it over post-judgment for a judgment that entered in 2015. We went to extend the judgment, or sorry, 2016. We went to extend the judgment, and the judgment extension was denied. And the court had stated that there was no signed order of judgment in this file. So we took a look at the file. We don't have a copy of it. The court doesn't have a copy of the signed judgment. And looking at the ROA,
Well,
there
we
were
couldn't
8.
have one if one didn't exist.
I completely understand and I agree with that. I think looking at the register of actions in this case, there had to have been a mistake somewhere of there's 2 certified judgment liens and 8 writs of garnishment issued after the motion for entry of default judgment on the ROA. So
Yeah,
at
but
this
the court
point,
speaks through orders. The register of actions isn't an order.
I completely understand. And that's why the plaintiff is here today filing for a motion for default judgment that there is, we don't show, so that the motion filed today for default judgment, it argues that the defendant was personally served in 2015. There has been no answer or otherwise defending or pleading by the defendant in this case. And so we would request entry of default judgment then at this point so that this record is cleared up and clarified.
And did you make any efforts to ascertain whether or not this address on 7641 Artesian Street is still a good address today for purpose of the notice of hearing?
So we did on import, our office does investigate addresses. I had no reason to believe that this wasn't the proper address for the defendant. We haven't
It
gotten
may
any
have been in
return.
2015, but it's 2026 now.
Let me pull it out and double check
Okay.
when the last skip trace we did on this address was.
It's a very uncommon name, so it should be easy. Hamadou Ba.
So the only thing I can point out or on this service address is that on 7/6/20,
It's the city of Detroit.
the address?
Yeah.
Yes.
Okay. Go ahead. Which one did you?
It looks like on 7/6, the defendant did try to call into our office,
Okay.
but refused to verify his identity, so we couldn't talk to him. We have super strict compliance under federal law, so we couldn't actually speak to him. But he did give us a call. So all of the pleadings, everything from our office only went to that address, and he would not have had our phone number unless he was receiving something from our office. So I have no reason to believe that the notice of hearing and the motion for default judgment went to an address that's not the defendant's.
Yeah, it's the address on Artesian Street. What's the address?
Yeah, it's the 7641 Artesian Street.
I'm gonna share screen with you. I don't know if you ever heard of this terrible website. It's called familytreenow.com. It's the worst website ever in terms of privacy concerns, but it's the best resource ever if you're trying to find somebody. I'm pulling it up. You should be able to see it in a minute. We're on YouTube, so I'm gonna try not to show too much. But it confirms that that's his address as of July 2026. See it? I'm gonna stop the screen share, but if you go to this website, you can scroll down and see all kinds of information, including email addresses and phone, just for the note, for
Oh,
note
man.
for future use.
I appreciate that.
It's free and it's quick. Like just it's an unusual name like Hamadou Ba. It's not a very common name. If it was like John Smith, it wouldn't be as accurate. But when it's an unusual name like Hamadou Ba, it's pretty accurate. I find it to be. It's one of the circumstances. Here's what I'm gonna do. This motion was set to be heard today at 9 a.m. It is now 12:32 p.m. I have reviewed your notice of hearing and it seems to me pretty clear that it had valid Zoom login instructions, which would have afforded someone an opportunity to access today's proceedings were they so inclined. I do believe that proper notice was given. Hamadou Ba has failed to appear or otherwise defend in this action since 2015. And I am in person in my courtroom today. No one has appeared in person to indicated that they were Hamadou Ba or here on Hamadou Ba's behalf. I do believe that you have met your burden. Your motion should be granted. Submit an order outside.
Thank you, Your Honor. Would you like that submitted under the 7-day rule, or can you e-file today is acceptable?
You can e-file it. Put it in it's not e-file, it's, what's it called, Kim? On base? Oh, she said it's the same thing. It's e-file. Submit the order, I'll sign it, okay?
No problem. I appreciate it, Your Honor.
And again, thank you for your patience.
No problem. You have a great rest of your day.
Seth, who's next?
Gentry v. State Farm default. The rest
You can go to
defaults.
me. Good morning.
Good
I mean,
morning.
good afternoon.
Good afternoon, Your Honor.
Thank you for your patience, Madam Clerk. Whenever you're ready, please call this case.
Calling case number 2501-0221 Gentry versus State Farm et al.
Your appearance for the record, please.
Good morning, Your Honor. Maya Green on behalf of plaintiff, Ms. Gentry.
Good morning, Ms. Green. This is your motion for entry of a default against a Omar Silla.
Yes, Your Honor, that is correct.
Hold on, before
Unfortunately,
you go too far, what we're gonna say?
we have been unable to serve Mr. Sila or Silla.
Okay. Serve him with what?
The notice of today's hearing. It was adjourned. This hearing was adjourned twice now. Once for the inability to serve him, and then the second time you requested an adjournment for me to redo the notice, for me to renotice it with the Zoom instructions on there.
Yeah.
And so that was done. My process server has been unable to serve him both attempts.
How'd you
Four
serve
attempts.
him with?
My apologies.
How did you serve him initially?
Well, the complaint was served through a process server. And so then this same process server has been attempting to serve him at that same address on multiple occasions to no avail.
Okay, so what you want to do? Do
Uh,
the court, hold on. I'm not sure that the court rules require personal service for entry of a default. I think it's notice. What are you asking me to do?
If we could adjourn it again so that we can attempt to serve Mr. Sila.
Okay, well, I think you might be, I mean, I can't give you legal advice or tell you how to practice law, but I think you might be doing too much. You don't have to personally serve him with, I could be wrong, check the court rules, but I don't think you have to obtain personal service for entry of a default. I
Every
think it's
time
notice.
Every time we try to serve him through mail, our mail returns, which is why I've been working with a process server.
Oh, okay. What's the new date, Kim? October 2nd, sure, new date.
Thank you, Your Honor.
Have a good day. Seth, who's next?
Advia versus Tashonia Brown.
Bring him in. Oh, is this the last one? It's
One
two
more
more?
after this.
Oh, good afternoon.
Good afternoon. Almost to the finish line.
I'm telling you. Whew. Thank you for your patience. Madam Clerk, please call this case.
Calling case number 2502. I got it. Calling case number 2502-260 Advia Credit Union versus Brown.
Oh, hold on. Your appearance for the record, please.
Good afternoon again, Your Honor. Alexis Solomon, P87454, appearing on behalf of plaintiff.
Again, tell me which case this is.
Your Honor, this is for Advia Credit Union versus Qiana Brown.
Okay, thank you.
Mhm.
Give me just a second.
Absolutely.
For some reason, I can't find it. Oh, I found it. Thank you for your patience. I have Judge Cusick sitting with me today, and he's rotating over from the criminal division to the civil division. So I was just explaining to him about the notice of hearing. So today is the date and time set for your motion for entry of default judgment. I do see that the notice of hearing indicates Zoom login instructions. It indicated this matter was going to be heard virtually today at 9 o'clock. It is now 12:40 p.m. No one has appeared on my Zoom and indicated that they were Tashanya Brown or here on Tashanya Brown's behalf. I'm also in person in my courtroom today, and no one has appeared in person. It indicated that they were Tashanya Brown or here on Tashanya Brown's behalf. I do believe that proper notice has been given and that the defendant has failed to appear or otherwise defend in this action. You may move forward with your motion.
Thank you, Your Honor. So plaintiff is filing its motion for default judgment under Michigan Court Rule 2.603B3, which enables this court to enter a default judgment against defendant for her failure to appear or plead in this action. This is a breach of contract action in which the defendant signed a loan agreement with plaintiff on October 6 of 2023. Defendant defaulted on the terms of this agreement by failing to pay as agreed, owing plaintiff damages in the amount of $26,428.22 plus interest, costs, and fees. Defendant was served by way of alternate service, in which a summons and complaint was mailed to defendant's residence on February 23rd of this year and posted at the same residence on February 25th of this year. Defendant failed to appear or plead within 28 days of service, and the default was entered against defendant on March 31st of this year. The entry default was served upon the defendant on April 24th, and then plaintiff filed this instant motion. Because defendant has failed to appear today, Your Honor, and has failed to appear or plead in this action in general, plaintiff would request its motion for default judgment granted today.
Your motion is granted. Submit the order. I'll sign it.
All right. Thank you, Your Honor. Have a great rest of your day.
And thank you for your patience.
Thank you. Have a great weekend, and nice to meet you, Judge. I'm happy that you're coming on the civil side.
Okay. He said thank you.
Thank you. Have a good weekend.
Miss, you could bring in the last person. Oh my God. Good afternoon.
Good afternoon, Your Honor.
Ms. Winslow, somebody had to be
Am I last? I know.
And unfortunately, today that was you.
That is no problem.
I would apologize, but you've been in your office. You've probably been working on other stuff, so it
I
wasn't that
have,
bad.
yes,
At least you weren't here in person like back in the day.
yes,
But I do appreciate your patience. Thank you for waiting. We had a
no
lot to
problem.
get through today.
Yes. And once I could watch on the clerk sent the,
YouTube.
yeah, because, you know, when you're in that room, you don't know what's going on. So I've been watching all morning. So that was helpful.
Yeah.
So I
Following
kind of
along
knew where
was helpful because it
you
lets
were in
you
the
know where you
docket.
stand.
Right. You're just
Yeah,
sitting
so I
there. No, so that was
appreciate your
really
patience.
helpful. No problem.
Madam Clerk, whenever you're ready, please call this case.
Calling case number 25019-682, Ford Motor Credit Company versus Williams.
Your appearances for the record, please.
Deborah Winslow, P 63179 on behalf of Ford Motor Credit Company.
Good afternoon. Today is the date and time set for your motion for entry of a default judgment. I do see that there was a notice of hearing that was filed in this case that indicated that this matter was going to be heard virtually via Zoom. It did include very detailed Zoom login instructions. That makes me very happy. I do believe that proper notice was given and that the defendant has failed to appear. I'm also in person in my courtroom today, and no one has appeared in my courtroom and indicated that they were here on behalf of the defendant, Tony M. Williams. So you may move forward with your motion.
Yes, Your Honor. As indicated, this is plaintiff's motion for entry of a default judgment related to the default on a motor vehicle lease agreement that was entered into for a 2000, I'm sorry, I don't have the vehicle information, sorry.
Are you trying, do you have the car? Are you trying to get the car
We
back?
did get it back. So it was a 2022 Ford Expedition Max.
Okay.
The defendant stopped making payments. It was charged off December 24th of 2024, and then it was recovered and sold at auction in May of 2025. We received, the auction proceeds from that. And after that's all been applied, there's a balance due and owing in the amount of $27,123.50. The defendant has failed to appear. We served the defendant via the court's order for alternate service, April 14th, 2026. The court entered a default entry on May 21st, 2026, and we served that upon the defendant June 2nd, 2026. Plaintiff would request that its motion for entry of default judgment be granted and that judgment be entered against the defendant for damages in the amount of $27,123.50 plus court costs of $387.50 and the statutory attorney fee of $75 for a total judgment of $27,586.
Motion will be granted. Submit the order. I'll sign it. And again, thank you so much for your patience.
You're welcome. Thank you, Your Honor. Have a nice day and a nice weekend. Nice to
You
meet you,
too.
Judge Cusack. We'll see you around, I'm sure.
He said,
All
nice
right.
to meet you
All
too.
right, thank you.